Hello and welcome back to the Fast Track Profit System. This is module number 1, video 2.5 REI Fundamentals, and the second video in a two-part series where we're covering the fundamentals of investing in real estate. My name is Cody Sperber, and in this video we're going to be covering the different types of encumbrances there are when dealing with real property, what the difference between junior and senior liens are, what are the different financing instruments used to secure a loan? And finally, we're going to be covering the two most common default processes found in the United States.
So in our last video, we started laying the framework and building your foundation for becoming a savvy and profitable real estate investor. In order to help you become the most adaptive real estate investor possible, I try and layer in more and more complex situations, investing techniques as we move through this course. Now, I believe that each individual brings his or her own unique set of strengths and weaknesses to any new task, including learning a new skill like real estate investing. The intensity of this course will gradually build until the last video, where it is my hope that you're going to have mastered the art of being an investor. Your fluid intelligence will grow as you acquire more knowledge about the 4 different investing techniques that we're going to focus on in this course. Before you know it, you're going to have the ability to analyze different investing situations, identify patterns and profit centers, and extrapolate relationships and money from almost any situation. I just want to say one more time how excited I am for you, and I really am truly thankful to be part of your investing journey.
Okay, so enough about that. Let's dive into the training. I want to start off by defining what an encumbrance is. It's defined as any claim, lien, or liability attached to and binding on real property which may lessen the value, burden, obstruct, or impair the use of a property. And essentially there are 4 types of encumbrances out there. The first one are easements. Basically, what an easement is an interest that entitles one party to some limited use of another party's property. A good example of an easement would be a roadway that goes through your land that your neighbor gets to use to access their land, because otherwise without it, he or she would be landlocked. The second type of encumbrance is a deed restriction. Now, these are private limitations that one places on land or property use. 2 examples of deed restrictions that you're probably going to see in your investing career are subdivisions, covenants, conditions, and restrictions known as CC&Rs, or when a bank puts a no sale for 30 days, 60 days, or 90-day deed restriction on an REO that an investor is trying to buy and flip. Now, obviously, we are creative, clever investors that have found a way around these REO deed restrictions, which I'm going to teach to you in a future training video. Encroachments are the third type of encumbrance. An encroachment is an intrusion upon another person's property without the right to use that, or the right to encroach upon it. 2 examples of encroachments are overhanging trees looming over your property line, or if a neighbor puts up a fence that's partly on your property without your permission. And the last type of encumbrance, and the one that is the most common out there, are liens. Liens are claims or charges against a property as security for the payment of debt. And in short, there's really 2 types of liens out there: involuntary and voluntary. Involuntary liens include property taxes, judgments, mechanics liens, and special assessments, which is like if they want to repave the roads in front of your house or something like that. And they pretty much get attached to your property whether you like it or not. That's what makes them involuntary. Voluntary liens include mortgages, trust deeds, or seller carrybacks, and they can only get attached to your property if you want them to.
What I want you to understand about liens is that they get ordered in a hierarchy depending on the type of lien and when that lien was created. We call this concept junior versus senior liens. Now, as you can see by this timeline, senior liens have a higher priority over junior liens. Now, what this means is that they're going to get paid off first in the event that the property is sold, and as the money gets distributed, each lien is going to get paid off in the proper order until all the money runs out. Whatever's left over after all the liens are paid off goes to the homeowner. Now, state property taxes, special assessments, and federal estate taxes are the most senior liens out there. Mortgages, like this bank loan number 1, maybe a line of credit, bank loan number 2, HOA liens, federal income tax liens, judgments, bail bonds. These are all considered junior liens, and they're going to get prioritized depending on the date that they were recorded. So maybe this one gets recorded first, and this one gets recorded next, and then if this one got recorded next, this would actually go in this position, and so on. Now, lastly is this little outlier called a mechanics lien, which are liens placed on a property if you don't pay your construction bills. And these are going to get prioritized based on the date that the work actually commenced. Now, the reason I call this an outlier is because even if the mechanics lien is recorded the day before a foreclosure auction or the day before the house is sold at foreclosure, the lien is going to get prioritized back into the order when the work first commenced. It's really important that you understand that. And it's really important for you just to understand this concept in general of lien priority, because many times you're going to find yourself working with an extremely motivated seller that has a major financial problem going on in their life. Now, if they're behind on payments or facing foreclosure or have a bunch of liens on the property, it's going to be a huge benefit to you for you to understand how this could affect your buying decision.
Moving on, let's take a second to talk about the two most common financing instruments associated with real property. They are note and mortgage and note and deed of trust. Let's first break down the different financing instruments individually, and then I'm going to show you how they get combined to secure a loan to a piece of real property. Let's start with the promissory note. In its simplest form, a promissory note is a contract where a borrower, otherwise known as the payee, promises to pay a lender, otherwise known as the payor, a specific amount over a specified period of time. A promissory note is signed in conjunction with a mortgage or a deed of trust. Now, a promissory note must include the date of origin, spell out the repayment period, the interest rate, and the amount of the loan, and it needs to include if there's a balloon payment or not, and also whether or not the interest is simple or compounding. Lastly, the note must be signed by all parties, and the lender typically holds on to the note, or at least the original version of the note, until the borrower satisfies the loan terms. You're going to end up seeing what a note looks like if you ever borrow hard or private money, or if you take out a loan from a traditional lending institution. A mortgage is a written instrument by which real property is pledged to secure a debt or obligation. The borrower of a mortgage has legal title and all rights of ownership, while the lender holds the lien and an interest in the property. When the loan is paid, the lender must remove the lien by recording a document called a satisfaction of mortgage on the property within 30 days or face a fine. Mortgages can be junior or senior liens depending on when they were recorded. And many real estate professionals will use the term mortgage to explain the type of loan that they took out against the property. For example, you might hear a homeowner or an investor or real estate agent say that they have a conventional mortgage or an adjustable rate mortgage or a VA mortgage. In reality, there are many different classifications of mortgages, such as conventional, adjustable, VA, FHA, blanket, open-ended, package, construction, purchase money, and hard money mortgages, just to name a few. These are nothing more than the details of the arrangement between the mortgagor and the mortgagee. What I want you to understand is that when combined with a promissory note, a lender can loan you some money and secure the loan against a specific property. There are 18 states in the United States that are note and mortgage states. The other 32 are note and trust deed states. Now, like a mortgage, a deed of trust is a legal document in which the title is transferred to a third party known as a trustee as security for an obligation owed by the borrower, known as a trustor, to the lender, who's known as the beneficiary. All right, so you have a trustee, trustor, and beneficiary. As in any trust, there are three parties involved: the trustor, the trustee, and the beneficiary. The trustor is the borrower and borrows money from the beneficiary, also known as the lender. In return, the borrower makes monthly payments to the lender, all the while the trustee is working for both the trustor and the beneficiary. It's kind of like an independent third party. The trustee can be an attorney, a licensed real estate broker, as long as they're not actively involved in the transaction, or a licensed insurance broker. In most cases, they're going to be an attorney firm, and they have two main duties. Their first duty is to record a document called a deed of reconveyance once the final payment is made on the loan and the loan's fully paid off. Bare title, which means that the trustee can sell the property if the loan is defaulted on, is transferred back to the borrower, and everybody goes on with their lives. However, if the borrower defaults on the loan, the beneficiary instructs the trustee to proceed with their second duty, which is to foreclose according to the laws that govern the trust deed foreclosures in that particular state. Like I said earlier, there are 32 states that are considered trust deed states, and like mortgages, trust deeds can be junior or senior liens depending on when they were recorded.
Trust deeds are very similar to mortgages because they both have similar clauses and types of classifications. Their primary difference is in the time and process involved in foreclosing on a borrower that defaults on their loan payments. And in many cases, lenders actually like using trust deeds over mortgages because the foreclosure process is just so much faster. With mortgages, judicial foreclosure is the primary way to take back a property, and this is done through the court system. With trust deeds, though, they can use both judicial and non-judicial foreclosure processes, but non-judicial is the most common way to take back a property if the borrower defaults.
Let's take a look at the general outline of the judicial process. Before I begin, I want you to understand that each state has different rules and laws pertaining to the foreclosure process. The following is just a general outline that most states follow. I highly suggest that you do some research to learn the exact foreclosure process of your target market. Okay, so the first thing that generally happens is the borrower violates the mortgage contract by failing to make the loan payments or by non-payment of property taxes. Second, the lender invokes the acceleration clause, calling the entire debt due and payable immediately. This prevents the lender from having to sue the borrower for each defaulted payment separately. At this point, the only way to stop the foreclosure from proceeding is to make up the past due payments plus any fees, pay off the mortgage entirely, file bankruptcy, which is really only going to delay the process, or by negotiating a deed in lieu, which I'm going to cover here in a minute. Third, if the proceeding continues, the lender's attorney is going to file suit to foreclose on the lien. The court's going to then review all the evidence, and it will order the property to be sold. If the borrower pays the entire debt awarded by the court, which is usually all those missed payments plus fees before the scheduled sale date, the borrower can stop the sale. This period is known as the equitable period of redemption, and each state has a different amount of time that it gives the borrower to redeem the property. If the borrower is still in default after this processing period, then the court is going to issue what's called a writ of execution, authorizing the sheriff to sell the property. The exact date and time of the sale must be advertised in a general circulation newspaper at least once a week for a couple of weeks to notify the public about the sale. Each state has different rules on how many public notifications must be made and over what period of time they must be made. Now, once the sale occurs, the buyer either becomes the owner of record or they're going to receive what's called a certificate of sale. If they do get a certificate of sale, that means that there's a redemption period in that state where the old owner can redeem the property by paying off in one lump sum the total amount owed on the loan plus prorated interest and any expenses incurred by the investor purchaser. If there's no redemption period, the purchaser is going to be awarded a sheriff's deed, and he's officially or she's officially going to become the legal owner. Like I said at the beginning of the slide, take some time to learn all the idiosyncrasies of your state's foreclosure process. In a non-judicial foreclosure, after the borrower defaults, the lender typically notifies the trustee and requests that the trustee begin to foreclose using a power sale clause. The trustee is going to file a document called a notice of default and an intent to sell. Each state has a different default period, where the borrower is given some amount of time to bring the loan current by paying back all the missed payments plus any fees incurred by the trustee. This period is known as the pre-foreclosure period, and during this time, the trustee is going to be notifying the public of the upcoming foreclosure auction. The sale is typically advertised in a local newspaper for a couple of weeks in a row, as well as posted on the property itself. Once the default period ends, the auction is going to take place and the property sells to the highest bidder. In most states, the winning bidder gets a trustee's deed sent to them within a couple of weeks after the auction, and the old homeowner has no redemption period. But there are a couple of states out there that give the homeowner up to 1 year to redeem the sale by paying all of the loan current, or paying back all of the loan, plus any interest and fees associated with that particular property. Check your local state's foreclosure laws to see whether or not your state has a redemption period after the sale.
Whether your state is a note and mortgage state using the judicial foreclosure process or a trust deed state using the non-judicial foreclosure process, once a property hits the auction block, one of four things is going to happen. Number one, the auction will get postponed. Number two, the property will sell to the highest bidder. Number three, the property will not sell and go back to the bank and eventually become an REO. Or number four, the sale will get canceled altogether. And since we're on the topic of foreclosures, I think right now is a really good time to review the three most common foreclosure alternatives. The first one is called a loan modification. A loan modification occurs when a lender agrees to modify the terms of the original contract agreed to between the lender and the borrower. Typical modifications include lowering of the interest rate, lowering of the monthly payment, or extending out the length of the loan. Much less common is what's called a principal reduction, and that's when they actually reduce the principal balance owed. And most lenders and servicers have an in-house modification program that homeowners can submit their properties and situations to. The next is called a forbearance. This is essentially a foreclosure alternative where a lender agrees to accept partial payments. The loan might be recast or extended, and in some cases, the lender may actually require a cosigner to jump on board or more collateral to get put up in order to secure the forbearance approval. The problem with both loan modifications and forbearances is that these are measures that are nothing more than temporary fixes or band-aids used to solve the homeowner's current financial problems. If a property is upside down, then neither of these foreclosure alternatives is going to help the homeowner in the long run. The last one I want to cover is what's called a deed in lieu of foreclosure. A deed in lieu occurs when a lender and a borrower want to avoid the time-consuming and costly process of a foreclosure. The deed in lieu is not as damaging on the borrower's credit as a regular foreclosure is, and the borrower can negotiate to avoid any deficiency judgments that may occur if they owe more than the property is worth. Not every lender is going to accept a deed in lieu, especially if there are other liens attached to the property. But when they do, the borrower simply deeds over the property to them and then mails the bank their keys. Well, you made it to the end of another training video. We covered a ton of the fundamentals, and I'm positive that you are quickly on your way to sounding, acting, feeling, and eventually becoming the local real estate expert that you're destined to be. In our next video, I'm going to show you which Power Team members are essential for your success as an investor, as well as show you the exact systems you're going to need to hire and then motivate them. Thanks for watching. This is Cody Sperber, and I'm going to see you real soon.